Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Doreen
And I'm Jennifer Wan.
Welcome to Hull on Estates. You're listening to episode number 654. How are you doing, Jen?
I'm great. How are you, Doreen?
I'm good. Not bad, even though it's kind of actually like pretty dark and dreary outside. I guess that is the beginning of December for you.
We just put up the Christmas tree and are in the office today, so that was pretty fun.
Oh, can't wait to see that.
Yeah.
So, Jen, what case are we talking about today?
So today we're doing a case analysis from Duhn Estate, so it's from Calgary, and we'll just talk a little bit about the cultural shift within the Canadian estate courts.
Awesome. Yeah. So I don't know if I know how to pronounce this last name. It's Duhn. So I'm going to say Duhn. And it is out of the province of Alberta. And we're going to walk through actually both the lower court decision as well as the Court of Appeal decision, because it's actually really interesting that by the time that this gets to the Court of Appeal in November 2022, the Albertans are already immediately picking up on the Johnson Estate decision from the Ontario Court of Appeal just 1 month prior in October. This is a case where, it's your classic estate litigation scenario, but rather than having your classic will challenge, this is about sort of the monies that mom had given away before she died. This is all about all the transactions that mom did 4 years before her death, because, lo and behold, when mom dies, sure, the family is very happy to see that everybody is equally in the will. All of the kids have the same interest, but it turns out some of them were quite upset to see that the estate was not as big as they thought it would be or should be because of some of these pre-death transactions that mom did before she died. So, Jen, do you want to walk us through specifically these facts in Duhn?
Sure. So the testator deceased, her name is Alice John Duhn. She died March 27th, 2018, age of 84. She had 7 children, lived on a farm with her husband, Robert Larson Duhn. He predeceased her about 4 years prior to her death on March 30th, 2014. So this is where that 4 years is crucial, because he left his whole estate to Alice. And so during the remainder of Alice's lifetime, she wanted to give away the money before she passed away. So she already announced that to her family as well, saying like during her lifetime, she's going to give most of the family estate away as to how she wants to. And she took precautionary steps to make sure she got what her wishes were, or to try to maintain her wishes, get her wishes granted. And so she did like transfers of real estate and gifting of large sums of money through checks. And so by the time she passed away, 4 years after her husband passed away, the family estate was a little short of 4.5 million. And so there were some family members, children and grandchildren, who were a bit disgruntled about the situation, questioning about what happened during those 4 years. The key point about this is them asking for financial disclosure. So they wanted to review the transactions she did during those 4 years, claiming that she lacked capacity, was unduly influenced, and there was probably fraud incorporated in her transactions, saying like maybe they forged her signature, even though within the facts, they kind of dispute that because it was just photocopies of records. And so everything was explained clearly in the case, but the main issue that was in question was, should the trustees disclose the testator's financial information before her death?
Right. Yeah. I mean, I think this goes back to what I was saying in terms of why there wasn't a will challenge in the first place. Okay, everybody was equally in the will, but everybody didn't get the same check in the 4 years leading up to mom's death, right? So, some people obviously got a little bit more before mom's gone. Some people got a little bit less. And guess who's the one that's bringing this to court by the time mom is gone? It's, the side of the family that didn't get as much. But, like with all families, it is really hard to sort of like treat exactly everybody equally at the same time, because maybe like not everybody went to mom with like requests.
Yeah. There's actually one weird funny point in this, and the facts was like one of the applicants was actually given $1 million check, but then that applicant tore it up, and so there's still question about all the transactions as well. So it's not exactly like about money, maybe just checking what's been through like between the siblings and the family members.
Right.
Yeah.
Do you recall why that particular applicant tore up the check? Did they actually?
It doesn't say in the public records, but I'm
Right.
pretty sure maybe they've gone through in their examinations and all.
Interesting.
Yeah.
So like in Ontario, I mean, like we're not lawyers who practice in Alberta. We just thought this case was really interesting because obviously the same scenarios are playing out across Canada. But, the moment you have the Ontario Court of Appeal being like very strict with like the minimum evidentiary threshold that's been established in case law for maybe like about like the last like 5 to 10 years. Like I think it's like always constantly building. Judges are constantly trying to take a harder look at cases earlier on just to see if they can like just help, the parties reduce tension, reduce legal costs, get to like quicker resolutions. That you just really are starting to have quite a bit of case law coming out of Ontario, like constantly people being like knocked out of the box like very early on because they're not able to meet this like minimal evidentiary threshold, because courts don't necessarily just always want to see yet another disgruntled family member complaining about what's left at the end of the day, when they don't really see, even on like the face of the lawsuit, perhaps like any concerns about the conditions of that testator at the time. And it kind of does sound like this is what, the judges were seeing in Alberta in this Duhn case. Like it sounds like, some of the family members threw the kitchen sink at it, questioning like signatures on like photocopies of checks, referring to like unconscionable procurement, just everything that you can think of in order to like challenge like those pre-death like transfers. But at the end of the day, were they even really able to point out to like mom's like questionable medical condition? It doesn't really seem like they were able to say very much, even though, mom was in her 80s when she died. But, hey, like they say, age ain't nothing but a number, right? And you certainly like can't judge somebody based on their age and, without more. And I think that's the whole point of this minimal evidentiary threshold is without more. It's like, can you actually get all of this information, put the estate through like 5 years of litigation only to find out at trial, like, no, really, there is not more to this than what you saw on the first day. It's like, can you save $1 million in legal fees, like right at the beginning? And I think these are the hard looks that judges are taking.
So the mom, like she actually maintained her capacity throughout her lifetime. There was only one incident where she had sepsis, so she lost her capacity for just a short period of time during that medical condition. But overall, she maintained her capacity, and like the applicants were focusing on that period of time where like claiming she lost capacity, so she doesn't have capacity. But like the court does look at the whole picture and not just one little thing. So you're definitely right about like the court having to balance whether or not it's like a fishing expedition or actually going through an analysis so like things don't fall through the cracks.
Right. Yeah. And I think like from the challenger's perspective, it is hard. Sometimes like you could actually have like some real concerns, but you just may not know anything about your mom's like medical condition.
Mhm.
Sometimes people are quite private, and if you're not the person that like goes with them to the doctor, you might not know. But in those cases, you better be really careful in sending out all those like illustrations of why you actually think there was a problem if you don't have like records and documentation of the problem.
Mhm.
And I think like a good quote, even from the Alberta's Queen's Bench decision, is that rarely, if ever, will the court order an investigation into a competent, and here competent is
Mhm.
italicized, testator's private pre-death financial affairs without an evidentiary threshold that raises a significant concern that there has been some potential abuse and needs to be investigated, and further, and then only after considering the testator's privacy rights. So there's
Mhm.
a lot of checks and balances that you see even in this like one sentence, which is,
Mhm.
like should be mindful of costs, right? Like that's what this threshold is meant to be for, so you don't get into like this crazy fishing expedition. But costs aside, even if there's like, and all the money in the world, what about the person's like privacy interests? Like that right
Mhm.
to do like whatever you want to do during your lifetime. Well, what good is that if after you die, people can like unearth every stone and just like undo what you did, right? There has to be something that like would actually like compel the court to actually exercise like some of these like really serious like powers that the judiciary have
Mhm.
in order to like have that look in. Like I think like, take this like exact same story. If mom dies in her like mid 40s and you want to question the transactions that she did when she was like between 40 and 44, that would be like kind of like ludicrous in a way, unless like
Um,
you just can like have like this like really really meaningful like evidence and case about how like maybe like mom was scammed, right?
mhm.
Like mom is being abused, mom is being brainwashed, but like all of that extra stuff would have to be there. And people should also like think about like older people the same way.
Yeah.
Yeah.
Um, yeah, so like even if someone like even if the applicants do meet the minimum threshold, like
Mhm.
there is a public policy side about valuing privacy and right of confidentiality. So in this case, the mom, like during her lifetime, she actually talked to the bank saying, like, I don't want this specific child to have access to my financial information. So the court knows like her intention of keeping her financial information private. So even if the applicants did meet that threshold, like balancing the privacy rights, public policy, it wouldn't have worked in their favor anyways.
Yeah. And I think that's why the Alberta Court of Appeal was also so like ready to adopt the Ontario jurisprudence and dismiss this one as well, because I think on its face, maybe like the evidence just like at the end of the day was not there. Um, Jen, do you want to maybe like get into some of those practical tips that we may have for individuals who are just trying to like organize their affairs, you know, give
Mhm.
things away before they're gone?
Yeah, so I really like this case because like there were like the lady did do a lot of practical steps to make sure her wishes were enforced. And so, for example, during will drafting, it's best to go to a law firm alone. Like, don't bring like an acquaintance or friend or family member with you, or if they do come with you, then make sure it's documented that there are separated rooms from you, so your lawyer is only getting instructions from you. So like if you know or you anticipate there might be some litigation between family members, you could probably include a no contest clause. There's in this case, we're also talked about a little bit about an adult child holding a joint account with their parents or acting as a fiduciary as a POA. Doreen, do you want to speak a little bit about that?
Sure. I think like another big area of litigation is the joint account litigation, and that flows from the Supreme Court of Canada's decision in Pacor, and that's been sort of it's been quite a long time that the decision has been there, and it's all about whether or not when you open a joint account with somebody, do you actually intend to give them what's left in that account by the time like you're dead, or vice versa, right? It has to be like that true gift of survivorship. And that has to be established right from the beginning, because that's kind of how bank accounts work, right? Once they open, you start to like, people start putting in their money gets spent, it's a big hole in and out. But at the end of the day, when you're gone, do you still actually expect and think like that's your bank account and that's not supposed to be like the other joint account holders? Or no, you're like, this is meant for you, whatever's left is meant for you. So in BCOR, the presumption is that like for, like married couples, like that right survivorship is there. It's like a family asset. But for like adult kids who come onto the account almost like for convenience reasons, where you're just like starting to help mom and dad with like their banking. But if you're going on just to help mom and dad with the banking, did mom really think you're coming on to get the whole bank account at the end of the day after, you no longer need help with the banking because, she's passed? That's the big question, right? And so like, but when you are actually going to open these accounts, it's a really good idea to like have all of that documented in your discussions with the bank, as well as sort of like even your own like internal records. And also like letting maybe like all of your kids know at that same time when the account is open, just so that everybody knows right from the beginning, hey, I just opened a bank account with your brother, and I do intend for your brother to get the balance when I'm gone. So Susie, this is the deal, this is what's happening, this is just so you know. And then that way, like, even the brother can very much well down the road point back and say like, hey, Susie, mom told you this, and then maybe reduce some estate litigation that way. Before we hop off, I do want to mention that because we've been talking about pre-death accounting, in terms of passings of accounts for people who are attorneys for property or guardians of property for someone in Ontario, the Substitute Decisions Act has provisions for who can apply to have a guardian or attorney for property pass their accounts. And for somebody that's like a child, you would actually need leave of the court. So the legislation where POAs and guardians are concerned about all these like, transactions that are done on behalf of, say, like an incapable person or like in reliance of a POA, that leave of the court is where the legislation is telling you definitely have a minimum evidentiary threshold requirement. Something to be mindful of. But obviously, like, that requirement does not apply to the person who gave the POA in the first place, or the PGT, the OCL.
Okay. I actually quite like the case law, like the Lower Cross versus Kelman, 2015 ONSC 19, and so it's about the POA trustee, fiduciary trustee person having to provide financial disclosure. And so I think the whole point is for you to provide disclosure, you need to have exercised your fiduciary duties and actually know and why decisions were made during that time. So for example, if going back to this Calgary case for Duhn, one of the daughters, she was put on a bank account, but she didn't exercise her powers under it, and she had no knowledge of any of the information and decisions made during the transaction. So the court actually focused like, how could you subject someone to explain transactions if a testator had capacity to make decisions on their own? So you couldn't actually ask a fiduciary party who didn't actually act during those transactions to provide information because they're not in a position to provide information.
All right. Okay, so that concludes our podcast. Until next time, we thank you for listening. I'm Doreen So.
And I'm Jennifer Rand.
Should you have any questions, please email us at info@hallandhull.com or contact us through the contact page on our website. Thanks.
Bye.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.